Welcome to CCI Toronto's Condo Convos, casual chats about important condo topics. Today's topic is about short-term rentals. So listen in and be on your way to achieving social and financial success at your condo. Before we get started, I'd like to extend our gratitude to our sponsor for this video, Duca Property Management, and who I'm sure is very experienced with short-term rentals. So, guys, how are you doing?
Good, thank you.
Awesome. So today we've got an experienced panel in condos. We've got Caroline Graham, who is a district manager with Dell Property Management. We've got Carol Dirks, who is a lawyer with Fogler, Rubinoff, and Brad Chaplick, who is a lawyer with Horlick, Levitt, Lella. So with respect to short-term rentals, just to get started, I wanted to talk a little bit about our experiences in short-term rentals, or as people like to think of them, Airbnbs, VRBOs, Booking.com, any of these new ways to book accommodations when you're traveling, or really anything that can replace a hotel nowadays that is happening a lot in condos. So in my personal experience, when I travel a lot, I go to Airbnbs because they're comfortable, I don't have to deal with a hotel, and I have all of the amenities that a condominium might have. But there's always a lot of issues as well around short-term rentals, and I'd like to get started with Caroline. How are you finding the experiences in condos and short-term rentals?
Challenging. Again, the enforcement issue is hard. Proving, first of all, that people are actually leasing out their units on these short-term sites are difficult. A simple address search doesn't always do it. You know, you've got to do a deep dive, look for pictures, look for angles. Is that our pool? Is that our, fitness room? We have one building in particular that is a condominium, but just because of where it is, right basically down Front Street at the Rogers Center, roughly 700 unit condo, and at the moment I think 410 of those units are run by short-term rental companies.
Okay, so I'm sure a lot of our viewers already know what some of the issues are, but what are the concerns around short-term rentals and condominiums?
For residents, mostly safety, I would say. We just had a recent issue at one of our newer buildings where there was a blood trail leading from an elevator on the 9th floor. Basically, you could follow the blood trail out to the street. People aren't registering. They're there for a day. They're there for, overnight. And it took us probably, I think, 4 days to finally identify that this unit was being used as an Airbnb unit. So I think that's paramount in most people's minds. We had, unfortunately, at another condo in the city, we heard about a shooting that happened, right on a floor. Luckily, no one was injured. But those types of things really scare residents.
Yeah, that makes perfect sense. Yeah. So, Carol, what do you think boards should be doing when they realize that they have a short-term rental problem, or is it even a problem from a legal standpoint?
Well, I think, first of all, it certainly can be a problem, as Caroline can attest to. I think what a lot of boards need to do is to look at, okay, what approach do we want to take with the short-term rentals? Because a lot of buildings, aside from what their documents might say, and I know we're going to talk a little bit more about that later on, but if it's not specifically enshrined in the declaration, what do the residents want? Some residents, depend almost on being able to offer their units for short-term rentals, especially living in Toronto with housing prices, etc. They want an ability to have some extra income. And so, when boards looking at how to deal with this, one thing to look at is, okay, maybe we should not just automatically prohibit them altogether. Maybe there's things we can do. For example, let's survey our residents. What do our residents want? Let's communicate more, either at owner meetings we have, whether it's a special meeting or AGMs, and just get some feedback. And if there is some desire to have short-term rentals, but with restrictions in place, what are those measures that we can put in? Can we have rules that those owners that want to have short-term rentals, that they have to do certain extra things to be able to do that? Or do we want to just say, no, it's not something this building wants, the owners clearly don't, and then we get into looking more at whether we have to deal with the condominium documents, or whether there's other things that can be done by way of rules, etc.
Fair enough. Now, Brad, when we were preparing for this, you brought up the fact that municipalities are trying to take short-term rentals into their own hands and try to regulate that. So can you tell us a little bit more about that?
Yeah, so there was a case was resolved in late 2019, and it basically upheld the zoning bylaw put in place by the City of Toronto. And the key features of that zoning bylaw are that in order to be a short-term rental operator, you have to be operating from your principal residence, and you will eventually have to get a license and pay taxes. And so this would restrict the majority of short-term rental listings that currently exist in the City of Toronto. Most nights rented are not from people's principal residence, and I think a lot of the problems that condominium corporations encounter are from these types of ghost hotels or commercial large operations, as opposed to people who just want a little bit of extra income while they're away from their home, as Carol was mentioning. And so these zoning bylaws are now have been upheld in Toronto, and there are similar bylaws in the GTA for principal residence and in some cases for licensing, pretty much in all of the surrounding areas for the City of Toronto and surrounding York region, Vaughan, Markham. All these places have their own versions of a similar bylaw.
Okay. And so Carol, back to you on that. I know you were talking about rules and possibly things in declarations that deal with short-term rentals. How do those interact with those municipal bylaws?
Right, so I guess the municipal bylaws on their own are, a way to automatically ensure that even if a condominium doesn't have something in its own documents, that there's going to be measures in place to protect the type of short-term rentals that are allowed. But if the condominium on its own has, either in its declaration or through rules that it's passed, prohibited these types of rentals, well, then that city amendment is really going to not affect what the condo has, because it's still going to be able to restrict the short-term rentals altogether in those particular circumstances. And I know one thing we were talking a little bit before is that the city bylaw amendments deal with allow it if it's your principal residence. And I know from recent experience in a couple of the condos we have someone who's claiming this unit is their principal residence. Clearly the board knows it's not, but then becomes an issue is how are we really going to be able to prove that? Because apparently their tax returns filed at that unit, they've got supporting documentation to show that that's their principal residence, and yet from the condo's perspective, they very well know that that's not. So that's going to add another element, I think, to how to enforce that bylaw and how to stop someone from doing short-term rentals even when they don't live there principally.
That makes perfect sense. And Caroline, how are you finding that in the condominiums that you manage, how are you identifying who is renting for short-term purposes? And
We will rely a lot on security. Buildings where, like I say, where there's 40 companies operating, it's not really that difficult. We've actually, in that case, set up an agreement with the short-term rental companies that basically to get all the keys away from our own security desk, that they would set up their own desk, they would do their own key turn or all that type of thing. Now that was before the bylaw was upheld, so it'll be interesting to see what as a go forward. And then you rely on residents. They'll tell you that they see frequent visitors to one unit, suitcases in and out all the time, that type of thing. People showing up asking for towels is usually a dead giveaway.
does that happen a lot?
It does, and that's sometimes what really, really annoys residents when they're there. I think if these people tried to operate a little more inconspicuously, it may have not come to this point, because I think a lot of homeowners probably were the driving force behind getting this bylaw passed.
Okay, no, that's completely fair. So when you are talking about these concierge desks that are basically being set up, I guess that sort of speaks to the ghost hotels that Brad brought up.
Yeah.
Can you elaborate a little bit more on these ghost hotels? What that term means?
A ghost hotel is a condominium unit that is being used basically solely for the purposes of a profitable short-term rental operation and not being rented out to any long-term tenant or being used by the owner as their own residence. And what the City of Toronto found and what the expert evidence in their case held was that even one of these ghost hotel units can change the character of a community. And I think in the case of, for example, a high-rise condominium building, just one unit in the building being used as a ghost hotel does change the nature of your condominium building, and it's something that I think boards of directors and property managers need to address.
That's completely fair. So, Carol, one thing that we were talking about that I thought was very interesting was the fact that how do you characterize these arrangements, these short-term arrangements? Are a lot of people in the industry sort of look at it as a lease, as a traditional lease, but I think you were saying that you don't quite agree with that necessarily.
So no, not necessarily, and I guess this gets into, if you're looking to restrict short-term rentals, you know, the starting point really is what does the declaration say about this? Because some declarations are very specific that clearly provide for short-term or transient use, a business commercial use of units by unit owners. But one case that we came across recently is where the declaration was silent about that, but there was in the leasing section references to the terms of leases that owners should be entitled to have, including leases for almost any term whatsoever. And the interesting thing from a legal standpoint is these Airbnb agreements, they're really not what is considered to be a lease, as that term is sort of considered at law. But is really more is a license, and a license is different from a lease because a license you don't actually have an interest in the land, and for the most part you wouldn't be subject to the Residential Tenancies Act, although there's some room in terms of that. But so, you know, if you're looking at your declaration and assessing what can we do with this, one thing to look at is, you know, is the provisions only dealing with leasing, and can we then consider this a license and perhaps still take steps to pass rules that would restrict that license arrangement?
Okay. And when you're trying to enforce these provisions, what are you finding are some of the greater challenges? If you're trying to tell a unit owner to stop short-term renting, how do you get them to do that?
Again, it's going to depend what the documents say. So if you have a clear prohibition, you know, there's your classic steps of usually an enforcement letter first. If they still fail to comply, there's some self-help remedies you might be able to exercise, especially if they're provided for in a rule, such as deactivating fobs, deeming people a trespasser. But then ultimately you're going to be left with the enforcement mechanisms in the Condo Act, so mediation and arbitration. And I know, Brad, you may have some other things you want to say about that as well.
Yeah, I mean, this is something I get asked a lot, to take enforcement action where you have maybe a specific rule that prohibits short-term rentals, or you might have a clause in the declaration saying leases have to be for a minimum length of 6 months or a year, and you have someone who's operating a short-term rental, ghost hotel, or it could be something less than that. And so I'm starting with a letter, and you know, the classic question is, can you take the cost of this letter and add it to the owner's common expenses? There's some case law that's perhaps going to make that a little more difficult in the future. That is, I think, very worrying to boards of directors and managers who rely on the pain of the cost of the letter as an enforcement mechanism. And also there's case law about turning off fobs and deeming people trespassers, and whether that is something that condominium corporations are allowed to do. And so, as Carol was mentioning, if you're going to have it in your rules, that's a better way to go. And I would probably recommend for any condominium corporation to turn their mind to having specific rules allowing for turning off fobs and deeming people trespassers, and turning their mind at least to the question of whether you need to have rules in place specifically addressing short-term rental.
Could I ask Brad a question, and Carol actually too? So given that, like you say, generally we get enforcement, people always ask at meetings, they ask, you know, why are these people allowed to get away with things? And you say, well, you know, we give them 1 letter, 2 letters, third letter generally comes from a lawyer and costs them $1,000, and that's generally enough pain to get them to comply. But now we're looking at people running units where I'm going to guess downtown average, they're making between $6,000 and $10,000 a month income. So really and truly, is the threat of that back charge, even if the back charge was enforceable, does it have any teeth anymore? I mean, really at that point, is it just, to me, a cost of doing business? You know, could we turn off the electricity to the unit?
I believe when we were talking about this too, you had also mentioned fines, implementing
Yeah, I mean,
penalties or fines. Is that something that would be permissible?
Yeah, I mean, would it be legally permissible? So if we do find these short-term ghost hotels running, at less than the 28 days, could we ask these companies that we already know are engaged in the building to put down a $5,000, $10,000 deposit that they would forfeit if they were found to be in breach of these rules? Would that be legally enforceable?
I think you're going to have a hard time with that. Yeah. There are amendments to the Condominium Act that are not yet in force that very clearly state that you cannot fine for a breach of rules or other governing documents.
I would love those people to live in condos before, before they create these rules.
So I don't think you're going to get very far with forfeiting deposits, but deactivating the fob, if you can do it in your rules and as a self-help remedy, if it's going to satisfy that, making it more difficult for people to run their businesses, and having vigilant security, and turning away people at the door when they come in and say, I'm here to check in to unit so and so, and the security just lets them on up, and they can say, no, I'm sorry, you're not here to check in. This isn't a hotel. And having those kinds of policies and post orders for your staff are sort of immediate steps that you can take. And then the longer term enforcement is perhaps mediation and arbitration with the owner, or perhaps going to court if you're dealing with a tenant.
Or even if going to court, if there truly are safety issues with the people that are coming in, there is a mechanism in the Condo Act to bring an application in those limited circumstances. And those carry a lot of cost consequences, obviously, for the ultimate owner. So if it's of that extreme nature, then you can up the ante a little bit more. Yeah.
So are you guys finding that in your practice you're seeing a lot of those types of issues, that escalation of real concerns with short-term rental operators that are causing those types of problems?
On a daily basis, to be honest. And what we're seeing more too now, and we haven't really talked a bit about it, is that even if the owner is complying, if owners that may lease their unit to a tenant for a year or longer, and then those tenants sublet out and operate a short-term rental business, we're seeing a much more frequency of that type of arrangement, and it's really difficult because the owners themselves are caught in a difficult situation. They don't want their tenant to be using their unit for short-term rentals, and it sometimes takes time to end that tenancy and to stop that behavior.
So in that type of situation, you've got an interplay there between the Condominium Act and the Residential Tenancies Act, right? Because there's that relationship between the condo, the owner, and then the owner and the tenant.
Again, another question, just so from a privacy standpoint, because we found ourselves in these situations before, and if we are aware now that a tenant has sublet, what position are we in terms of being able to inform the owner?
Well, the owner has a duty, obviously, to register, and the tenant then would to register with the corporation. So I think you could certainly inform the owner. But also the condo needs to be careful not to then become an agent of the owner, because in the Residential Tenancies Act, if the condo was to be an agent to try to remove the subtenant, then there can be liability. So it does become a complicated situation.
Yeah, I mean, to answer your question about privacy, in my view, the owner has the right to know if someone is in their unit. And so I don't see any difficulty for the property manager calling the owner up and saying, hey, we've got a person living in your unit by the name of so-and-so. Is this your tenant? Do you know about this? Yeah. I don't think anyone's going to say that their privacy was violated because you told the property owner that they were living there.
Okay.
All right, so we're coming up on our time, but before I finish off, I guess I wanted to ask each one of you, do you think that with the measures that are in place now, with the things that you can do with the Condo Act, the declaration and the rules, and with the new zoning bylaws, are things going to get better or worse in condominiums with short-term rentals? I'll start off with you, Brad.
I think things are getting better. I think the combination of strict zoning bylaws and boards and managers getting used to passing rules and enforcing them is going to make things easier, and that I predict that this problem is going to get better and not worse.
How about you, Carol?
Very quickly, I agree with you. I think it's getting better, but with the caveat that inherently people like to break the rules. People they like to take chances, and they'll do everything possible to ensure that. And I think we're still in for some difficult times on this issue coming up.
So some growing pains almost.
I think so.
So, young guys like me who rent an Airbnb to host a party for the weekend and not have to do it at their place, right? Carolyn, do you ever see that?
all the time, and that's what the problem is.
Yeah. So do you think it's going to get better, or do you think it's going to get worse?
I think enforcement is always going to be an issue regardless of what types of bylaws are in place. So that's always going to be the challenge.
Okay. Well, thank you all very much, and I hope you guys enjoyed everything about this conversation and talking about short-term rentals. So if you have any questions, I'm sure half the panel here will tell you to go talk to your lawyers and ask some questions. Thank you very much.